I'm reading from the fifth line on para 33. In the absence of any mandate under the statutory rules or the administrative directions, we are unable to hold that the state government employees are entitled to get DA at a rate payable to employees by the central government. So that's clearly, I would understand, in our favor. However, from the discussion made by us herein above, we can hold without hesitation that the state government employees are entitled to get DA on the basic pay at the rate to be calculated on the basis of AICPI number published from time to time by taking the base year 1982. It is the bounden duty of the state
that he is to ensure compliance of our interim order. Only he can get that.
Yeah,
Just tell him. Please proceed.
Sorry, I was on page 484, paragraph 33.
Yes.
And Manoj, I read the first two sentences of that paragraph to be in my favor, in the sense that it rejects the notion that whether there is a mandate for the purposes of parity between state government and central government. Now, Manoj, I'm reading on. I'm reading from the fifth line on para 33. In the absence of any mandate under the statutory rules or the administrative directions, we are unable to hold that the state government employees are entitled to get DA at a rate payable to employees by the central government. So that's clearly, I would understand, in our favor. However, from the discussion made by us herein above, we can hold without hesitation that the state government employees are entitled to get DA on the basic pay at the rate to be calculated on the basis of AICPI number published from time to time by taking the base year 1982. It is the bounden duty of the state government to evolve norms and principles for payment of DA to its employees by calculating the same on the basis of AICPI on the basic pay fixed in terms of the ROPA Rules 2009 till the date of giving effect to the recommendations. Now it talks of the 6th Pay Commission set up by the government of West Bengal. The state government is also duty bound to pay arrears of DA to its employees after fixing the rate on the basis of AICPI number before implementation of the report of the 6th Pay Commission set up by the government of West Bengal.
Can you read this again?
Yes, I'll read it again, but I also need to follow what we are trying to say. So, Manoj, may I start with the word however? However, from the discussion made by us herein above, we can hold without hesitation that the state government employees are entitled to get DA on the basic pay at the rates to be calculated on the basis of AICPI number published from time to time by taking the base year 1982. It is the bounden duty of the state government to evolve norms and principles for payment of DA to its employees by calculating the same on the basis of AICPI on the basic pay fixed in terms of ROPA Rules 2009 till the date of giving effect to the recommendation of the 6th Pay Commission set up by the government of West Bengal. The state government is also duty bound to pay arrears of DA to its employees after fixing the rate on the basis of AICPI number before implementation of the report of the 6th Pay Commission set up by the government of West Bengal. We would like to observe that the state government has the discretion to make payment of arrears of DA to its employees and fund with suitable restrictions on withdrawal of the same within the specified period of time. The first issue, whether the employees of the state government are entitled to get DA at the rate payable to its employees by the central government, is decided accordingly. So now, let me just make an effort to try and unpack this or unravel this, or what my understanding of it is. What they say in categoric terms is, one, you are not entitled. Really, that's my reading of it. There is no equivalence between state government and central government. That's the first part of paragraph 33. Categoric. There is no such mandate. There is no such obligation at all as far as the parity is concerned. Because that's the question which he had framed, you remember, when the tribunal had framed, and which they are endeavoring to answer. Then they say, however, And they bring in some notion after, however, to say that it's the bounden duty of the state government to evolve norms and principles. Please see this. To evolve norms and principles for payment of DA to its employees by calculating the same, and then they make a suggestion as to how DA is to be calculated. Now, this is entirely outside the province of the tribunal, completely outside. This is entirely within the state government's province as to decide how to calculate DA, how much to give, and the methodology. Because I can understand that if there is some arbitrary methodology which is prescribed under the rules of the memorandum, someone has to challenge that. Challenge it squarely, get it struck down, and then of course the state government may have to, if it fails to sustain the methodology which it is adopting, it may have to come up with something new. But when you have an extant rule which is not challenged and which is not struck down, when you have an extant set of government memoranda from time to time, revising it, and you saw those rates going up, you have it, there is an application of mind. None of those are struck down. None of them are even challenged. We are paying in accordance with them. But then to foist through this backdoor method, whatever it means, by saying you must evolve some norms and you must evolve some principles, and you must thereafter, if there are arrears on the basis of those evolved norms and principles, pay the arrears as well. But we give you some flexibility as to how those arrears are to be paid, whether in cash or some credit to the provident fund. So this is at least my understanding of this. We'll come back to this because it returns in the operative directions. Now please go to page 488. So here I'm going to just in a sweep read paras 37 and 38, and then I'll come and I'll make my comments.
Please.
Para 37, page 488. This is the concluding portion. While remitting the case back to the tribunal, the division bench, this was the earlier round where we had succeeded, the division bench of the High Court has emphatically decided that the state government employees have the right to receive DA on the basic pay in terms of the ROPA Rules 2009. The tribunal was called upon to decide two issues which have been addressed by us, giving our observations. The upshot of our observation is that the state government employees are entitled to get DA on the basic pay fixed in terms of the ROPA Rules 2009 at a rate to be calculated on the basis of AICPI number 1982 equals 100, published from time to time till the date of giving effect to the recommendation of the 6th Pay Commission set up by the government of West Bengal. The state government employees are also entitled to get arrears of DA on the basic pay to mitigate the loss of value of basic salary due to inflation after calculation of the rate of DA on the basis of the AICPI number 1982 equals 100 within a period of 1 year or before giving effect to the recommendation of the 6th Pay Commission, whichever is earlier. The office orders, memorandums under which DA was paid to the state government employees working in so-and-so, this is in New Delhi and in Chennai, at the rate payable to the employees of the central government are struck down as arbitrary, unreasonable, and violative of Article 14 of the Constitution of India. This order will not stand in the way of giving any incentive to the state government employees working in New Delhi and Chennai by way of special allowance or any other allowances to compensate the loss suffered by them for their posting at a place far away from the state of West Bengal. The function of pleadings is only to state the material facts, and it is for the court or tribunal to determine the legal result of those facts and to mold the relief in accordance with that result as decided by the federal court in Messrs. Mulji Jetha versus Khandesh Spinning, reported in AR 1950 Federal Court 83. Accordingly, we would like to give the following directions on the basis of the findings made by us. The respondent number 1, Chief Secretary to the Government of West Bengal, is directed to evolve norms and principles within a period of 3 months from the date of the order for release of DA on the basic pay of the state government employees fixed in terms of the ROPA Rules 2009 by taking into consideration inflation on the basis of AICPI number 1982 equals 100, so that DA can be paid to the state government employees at least twice in a year till the date of giving effect to the recommendation of the Sixth Pay Commission by the government of West Bengal for its employees. The respondent number 1 is directed to implement the norms, principles evolved as per direction of the tribunal within a period of 6 months from the date of the order. The respondent number 1 is further directed to make payment of arrears of DA on the basic pay to the state government employees by taking into account level of inflation on the basis of the AICPI number 1982 equals 100 by following norms and principles evolved as per the directions of the tribunal within a period of 1 year from the date of the order before giving effect to the recommendation of the Sixth Pay Commission set up by the government of West Bengal, whichever is earlier. The respondent number 1 is at liberty to decide the mode and manner of payment of arrears of DA to the state government employees within the period of time fixed by us. The respondent number 1 is also directed not to give effect to any effect to the office orders and memorandums issued for payment of DA to the state government employees posted in New Delhi and Chennai at a rate payable to the employees of the central government by the respondent number 1 will not make any recovery for excess payment of salary to those state government employees. The respondent number 1 is at liberty to give incentive to the state government employees working in New Delhi and Chennai by payment of special allowance or any other allowances the state government may deem fit and proper. With the above directions, the original application stands disposed of. The urgent. Now, just please note, since your lordship has this, if you can just go to the fourth last line on page 489. Beginning, the respondent number 1 is also directed not to give effect. Your lordship has that?
Yes, sir.
Right. So that portion till the end of paragraph 38. End of paragraph 38. We are not challenging. We have accepted it. Right, wrong, good, bad. As far as those Delhi memorandums and Chennai memorandums are concerned. So that need not trouble this court. What we are really concerned about is the operative directions, which your lordship will find beginning with about 7th line in para 38. The respondent number 1, Chief Secretary of the Government of West Bengal, is directed to evolve. Your lordship has that. From that until ending with the words employees within a period of time fixed by us. This is really the problem area as far as we are concerned. Now let me just make an effort to try and understand what the directions are. The directions, according to us, first and foremost, they do not, and this is very important, they do not upset the scheme under 2009 ROPA rules. That's the first point. They don't say this is bad, this is to be nothing. So the ROPA rules have full force and continue to have full force. Second, on our understanding, they do not disturb any of the memorandums issued pursuant to these ROPA rules either. I have told you, Lordship, the portion is concerned, neither are the rules struck down, nor are the memoranda even touched. However, they introduce 2-3 notions. The first notion which they introduce is, which your Lordship will find, an obligation to evolve norms and principles. Now, what are these norms and principles? I already have rules. I already have government more. So they introduce this notion is directed to evolve norms and principles. Then they seem to suggest, going through the rest of the thing, that that base figure which is provided in ROPA is also required to be shifted under these new norms, etc. And payments are then to be made twice a year until the Sixth Pay Commission, which is lies in the future, comes into force or whatever's earlier. So in short, this is an exercise without finding any fault with the existing regulations, directing legislation to take place because they want a new law for the purposes of bringing in parity. That's the long and short of it. Because you saw that they trace in that table. They hold that there can't be parity. But then through the back door, they introduce this direction and obligation to revise without finding any infirmity, without finding any infirmity. So the obligation is not a public duty to pay under some rule which we have been deficient in doing. That's one thing. That look, you have this rule, you promised this DA, but you are failing in your public duty by not following up with your own norms and rules. That's one thing. No, that's not the direction. The direction is revise.